We can take any match set that you have, Marianne. Ms. Ellison, are you ready to proceed with Ms. Ray?
We are, Your Honor.
This is 210731 LT Peter Fraley versus Jeremy and Andrea Ray. Your appearance, please.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 on behalf of the plaintiff.
Your name, ma'am? You're muted.
Oh, sorry about that. Good morning, Your Honor. It's Andrea Ray, 9523 Washington.
Have the parties had an opportunity to speak this morning?
We have, Your Honor. Ms. Ray is going to participate in the SARA program. She called Wayne Metro and they have her on a list. She's going to reach out to Lakeshore Legal Aid today to see if they can assist her in the process in filling out all of the paperwork and representing her in this matter. So we would just ask for a brief adjournment.
What's brief to you, ma'am?
Well, I don't think they are accepting applications, or they might be accepting applications for SARA. I'm not sure. So I guess I would say 3 weeks, and maybe we can come back and just check the process.
So 3 weeks puts us at March 31st.
Okay.
So I made a note in the file to adjourn 3 weeks, 3/31/2021, and the clerks to notice the file. I'm assuming 9 o'clock.
That works for me. It works for you guys.
Anything else, Ms. Ellison?
No, Your Honor. Thank you so much.
Anything else, Ms. Ray?
No, thank you.
We're all set. Have a good day.
You too. Thank you.
Thank you. Good morning. Are the parties ready on NME versus Urban Barber?
Your Honor, this is Attorney Sean Hermes. I'm gonna have my client log on right now. I told him to wait a second. I can have him in just a minute.
Mr. Hemmis?
Yes, can
The
you hear me?
question is, are you ready or do you need to speak to someone else first?
Oh, I'm ready to go. I just need my client to log on really quick.
Mr. Robinson?
Yes, Your Honor.
One of your defendants is here in person, Charles Nelson.
Oh, okay.
Would you be ready to proceed in that matter, or do you need to speak to Mr. Nelson?
I would speak to him first. I believe Mr. Palitz should be logging on as well, too. I am more than ready to talk to Mr. Nelson, if he's there.
Good morning, Your Honor.
Good morning, Mr. Palace. How are you?
I'm doing fine. As you can see, we, due to the size of our docket, we've got 2 attorneys working today. So we want to try and make this as procedurally seamless as we can.
Famous last words.
Well,
your tenants,
I might have
as your
jinxed it,
tenants are
yeah.
available, as your tenants are available, Marianne will match up and put you in a breakout room if that's what you need.
Great. Great. I do anticipate we'll probably have a lot of defaults. There are a lot of people who did not show up at the first hearing. So we'll be able to glean through this docket and then go from there.
Sounds good.
It's good to see you on the bench.
Mr. Robinson.
Congratulations again.
I have a defendant here by the last name of Veazey. Do you want to go into a breakout room with him?
That works for me. What's the last? Oh, VZ, I see.
Yep. Hold on 1 second, please.
How long are you going to give tenants for defaults?
Well, since they're filling up our waiting room, will probably be about 9:30-ish.
Okay, that's fine. We'll take our cues from you.
Thank you, sir. Mr. Hermes, do you anticipate a hearing in this matter, or is there something else?
We anticipate a hearing in this matter, Your Honor. It shouldn't take too long, considering the facts, but I don't think we're gonna be able to work out a deal in any.
Well, I can't see our waiting room, so I'm not sure if your client is here yet, if
He
they're
sent me-
properly named.
He did send me a picture of him in the waiting room. Just please wait. His name is Nawaf Kaleshu. I don't know if you can see the names or. There he is.
Do you need to speak to Mr. Davis?
Sorry, me?
I do not, Your
No?
Honor.
Okay, there's one hearing that I need to go to call before yours. This is 210304 Lakeview Mobile Home Court versus Anthony Cigarelli and Michelle Callahan.
Robert Coots on behalf of Lakeview Mobile Home Court, 43430.
Mr. Cigarelli? Mr. Singer? Sir, with the blue shirt on and cap,
Yes, ma'am.
your name, please?
Anthony James Signorelli.
I just called the case. The attorney for the plaintiff has already put his appearance on the record. We're here this morning on your motion to set aside a default judgment. Actually, it's a consent judgment.
Yes,
Are you
ma'am.
ready to proceed this morning?
Is there a way I can get adjourned for another day?
Because
Because we came up with new information that we didn't know before. And I wasn't able to submit proper documentation.
your name, ma'am, your name?
My apologies, Brittany Callahan.
Ms. Callahan, I see a Michelle Callahan.
Yeah, that's my mom, who, I don't know why she's on there. She didn't live with us. We have like 3 different copies of a different lease that they've given us.
Ma'am, you're not a party to this action. I'm looking at the file and there's only an Anthony and a Michelle. So unless you're, ma'am, unless you're a licensed attorney, there's no conversation that you can participate in.
I'm right here.
on the
I'm
record.
Michelle Callahan. I'm right here.
Can I talk to my son who's not old enough?
Hello.
The reason we're here this morning is that a motion was filed challenging the consent judgment that entered.
Yes, ma'am.
So that's the conversation we're having this morning. The consent judgment that was signed on February 10, 2021, there was an indication in your motion that there was misinformation relying upon entering that consent judgment.
I just, when at the time, I really didn't understand my rights, and what I was giving up and what was going to come after with the consent signing. I didn't even have a lawyer too when I was signing it. So I honestly, really didn't know what rights I was giving up, ma'am. And that, like I told the attorney, that I felt like I was in the right with everything that was going on. And I just felt like I was pushed into doing it. And I didn't know all these rights I was going to be giving up, as in like a judgment, eviction, something on my record saying I couldn't rent again. And
I'm Michelle Callahan. I'm Brittany Callahan's mom, his fiance. How are you?
Good. But let's stick to this. So, Mr.
Yes, ma'am.
Did you receive a copy of the summons and complaint that told you needed to come to court or call into the court on February 10th?
Yeah, I did, yes.
And that document indicates you've been summoned to court, that you have a right to a jury trial, that you have an opportunity to give the reasons why you feel you should not be evicted, and that you could be evicted without a trial and a money judgment if you were not in court on time? You received
Yes.
the document?
I got a document saying to come to court, and I was there that day.
When you received that summons, did you also receive a yellow sheet of paper?
I did. It was for the legal aid.
Correct. So that information regarding accessing an attorney?
Yes, ma'am.
Okay. So what happened on the 10th that you don't believe that your rights were respected or that you had information?
Yeah, I have emails state from legal aid said they couldn't provide the help to go to court with me and all that stuff, to provide the help.
So the basis for your motion to set aside the consent judgment, I'm still waiting to hear it, sir.
We couldn't get legal help.
We couldn't get legal help, ma'am.
No.
I have from DHS approved PP SCR saying that they would help pay if the balance I felt like I owed. I just didn't have the right documentation and at the time, and I was waiting for it. And it was denied because I didn't get it in time for them.
I can only hear one of you at a time. So if that's the other named party and they have something to say, they can step and say.
I'm just saying they've been through a lot here with people. They've not fixed anything. I came over to spend the day with my grandson. I kissed them all over, and I ended up getting a bacterial infection in my mouth from the mold that's in their home. I'm so sick. My immune system is low because I had chemo and it's over, and get mold sickness in my mouth from my grandson is ridiculous. This has been going on for so long for them. My daughter's depressed. She won't even go out of the house because these people have pushed her around for so long. And my soon-to-be son-in-law has done everything in this house, taken down walls to put walls back up where there were mold that they had time and time again told them they would come and fix it. And there's so much damage to their property. They didn't even get a key until 2 days ago or 3 days ago to their apartment. They had to leave it open for a whole year.
Anything else, ma'am?
I just think that these people need to compensate these guys in some way, and their children are being affected medically. And if I'm getting a disease from my grandson, who's only a year old, they need to, do the right thing. They're got some shady stuff going on. They've changed their businesses names. They've changed them to nonprofit because they're on the Chamber of Commerce here in Belleville. they think that they can do whatever they want. Well, they didn't do anything at all to help these kids. Not help them above and beyond, just help them get their apartment living. And if they didn't have the money to move out, or they darn sure would have.
Anything else, ma'am?
We did try to move. Just with everything going on with a lot of people didn't want to rent out because of the virus or my employment. I was laid off at the time. I just, at the beginning, they said they had a death in the family, why they couldn't make the repairs, that they went through so many maintenance men, also why they couldn't make the repairs. I just did so much to this place, and I just feel like I should be able to get somebody to represent myself. Obviously, we're doing the best we can to represent ourselves, but, we don't know much about this, and I just feel that we should be able to get a lawyer. My name's not even supposed to be on this. I never co-signed for them. I have no idea why my name is on there. We have sex offenders that live in here that we were never told about. I don't feel like I'm in the wrong, and if I felt like I was in the wrong, I wouldn't be here arguing my case or even justify something I did wrong.
Anything else, sir?
My wife, Brittany, the lease that we have, she's on. The one they mailed me is, I don't really understand. It's not the one that we have, that was signed. Because she's on, Brittany's on the lease. The one that I have shows that she's on the lease. And then the one that was mailed to me in that packet with the yellow sheet, she is not on the lease, which she isn't. She lives here.
Anything else, sir?
And I'm just curious about this CDC order as well, too. I think I sent that in also. I think I did it right. I'm not really sure.
Anything else, sir?
No, ma'am.
Mr. Cooch, your response.
First off, they received a notice to quit dated by me on November 18th, 2020. That was mailed out, first class mail. So they've had since roughly November 20th of 2020, as far as notice. And then, of course, they got the complaint. The consent judgment was explained to Mr. Signorelli on February 10th. We went back in from the breakout room and talked with the judge, the court clerk, the civil clerk, and put the terms on the record there. He was in full understanding of it. All of the excuses or items that they're claiming does not fit within Michigan Court Rule 2.612C as far as relief from a judgment. At this point, I'd ask the court to deny the judge or deny their defendant's motion.
Thank you.
I got
Anything else on behalf of the defendants?
I had a verbal agreement with the landlord the day he came over. It was actually 3 days. I got the notice 2 days before I had to go to court. I had it on my door, but I talked to the landlord. We were in agreement to work all this out. This eviction is new to me, honestly. It's we were never supposed to go to court. We were supposed to take care of this. In October, we met. We had a lot of problems in the beginning. We met in October. He reimbursed me some money towards my rent, and in October we're squared off. And then they're saying I owe all this money, but I have receipts showing that I paid in one of those months that they're saying I owe in. Which, and top of that all, I met with when I talked to first she tried to hire me to do all the repairs in the house myself for $10 an hour, and I told her I can't do this. Maybe some stuff like some basic stuff I can do, but I can't do no major repairs. And especially for $10 an hour, I was working at the time. Ma'am.
I'm here and I'm listening to you. Here's the issue that we have that's before the court this morning.
Okay.
The parties appeared on February 10th for a termination of tenancy case. You acknowledged to me that you received service of the summons and complaint in this matter, and the yellow sheet that the court sends out that advises you of your rights, that gives you the contact information for Lakeshore, that gives you a plethora of information about these proceedings. As Mr. Coops pointed out, you were served with a notice to quit back on November 18th, 2020, that advised that you must move by December 20th, that the landlord could take you to court to evict you, and that you may have a lawyer advise you. I asked you specifically this morning what your challenge was to the consent judgment. You've acknowledged to me that you had sufficient information to proceed on the morning of the hearing. You did not request a hearing. What you did was agree to enter into a consent judgment. For those reasons, your motion to set aside the consent judgment is going to be denied.
That's
Anything
ridiculous.
else in this matter, Mr.
Yeah,
Coops?
that's ridiculous.
Thank you. No.
Anything else on behalf of the defendants?
How do I go back to counters? Two things. I want to see if I can appeal it to a higher court, and then second, a counter sue.
You haven't, sir, what you have is an absolute right to appeal my decision.
Yes, ma'am.
The court cannot give you legal advice on how to proceed in either appeal or countersuit. We can't provide you legal assistance in that fashion.
Okay,
If you've already contacted Lakeshore, you can follow up with them, okay?
All right, because the yellow paper you gave me, the number I called, they told me to bring it up to you that I wanted to counter sue. So I'm saying that because that's the information I was given from the yellow sheet.
I understand. I've made my ruling. Have a good day, sir.
Okay, ma'am.
Thank you. Mary Ann, has anybody else made it and ready?
Yes, Mr. Robinson, Mr. Palitz, they're here with VZ and Cox on your screen.
210666 LT Van Buren Estates versus VZ.
Garrett Robinson with the plaintiff P83881. Mr. Veazey and I talked in the breakout room. I believe that we've reached a consent judgment for him to pay the amount owed by the end of the month. And we can.
I'm sorry, what would that amount be?
I have rent to retain at $1,976.05, costs of $188.00 for a total of $2,164.05.
Paid by?
March 31st, 2021.
And you'll submit the consent judgment to the court?
I will, Your Honor. Thank you.
Mr. Veazey, take your hood off, please. You heard the comments made by Mr. Robinson this morning?
Yes.
And it's your desire to enter a consent judgment with the plaintiff indicating that you will pay rent to retain of $1,976.05, cost of $188 for a total of $2,164.05.
Yes.
Sir, you've had an opportunity to read the summons and complaint and all the other attachments to the landlord tenant matter?
Yes.
Okay, what's going to happen is Mr. Robinson's going to submit a consent judgment. The court will sign it and you'll get a copy in the mail.
Okay.
Your Honor, just on the record, may I ask Mr. Veazey for permission to sign for him on the consent judgment?
Yes, that's fine.
Anything else, Mr. Robinson?
Nope, that's it for this case. Thank you.
Anything else, Mr. Veazey?
No, ma'am.
I'm sorry, where's Michael Veazey?
He's not present at the moment.
Was he aware of this morning's hearing?
Yes, but he couldn't make it due to a different living situation.
I'm not going to probe that any further. I'm going to indicate in the file, though, that only Tommy Veazey was present. Anything else?
No, ma'am.
Thank you. Have a good day, Mr. Veazey.
Thank you.
Yes, thank you, sir. Mr. Robinson, did you have any other cases ready?
I believe Mary Ann's asking me to go to Mr. Stubbs now. So yes.
Thank you.
Go in the breakout room.
Jennifer Cox, are the parties ready?
Yes, Your Honor.
Ms. Cox went into a breakout room as soon as she comes back.
Oh, she probably was mistaken to do that. Why don't I do this? Why don't I go get her?
No, Mary Ann's talking to her, sending her back right
Oh,
now. I'm scared
okay.
if you leave,
You'll never find me again.
I'm sure I'll find you like the bad penny you are. Does she
We're
not
gonna have-
understand how to get out?
Maybe we're gonna ask for adjournment on this matter anyway, Your Honor.
Listen to Mary Ann explain to her how to get out.
Right.
Did you have anything else ready?
I don't believe so. I don't know if there are any tenants left. These were the only first two tenants that my associate and I had an opportunity to discuss with. I don't know.
I'm gonna call another case when Ms. Cox pops back out. I'll call that
Okay.
case next, okay?
Thank you, Your Honor.
This is 210589 NME Group versus Urban Barbershop and Brand.
Good morning, Your Honor. Sean Hermes here on behalf of NME, the plaintiff.
There we go. Sorry.
Mr. Davis?
Yes. Hello?
Hi, did you hear me call your case?
Yes, I did.
Okay, your full name, please.
Alyssa Janelle Davis.
And your relationship to Urban Barber Shop?
The owner.
Can't see you.
Oh, sorry.
That's okay.
Can you see me now? Ma'am?
I cannot. Are you ready to proceed this morning?
Yes. Hello?
There you are. You can take your hat off for me, please. The plaintiff has indicated that there will
Sorry,
be a
it
hearing.
won't,
That's
like,
okay.
it won't go to speakerphone.
No, you're fine. Can you hear me?
I can hear you.
Then stop whatever you're doing, point the camera at your face, and we're going to start your hearing.
Okay.
Okay? You are ready to proceed this morning?
Yes.
Are you driving?
Yes, I have to go to an infusion. So it's at 10 a.m. So I had to drive at the same time.
Okay, I can't do the hearing while you're driving.
Okay.
When you get where you're going, well, how far are you from the infusion site?
I have to go to Detroit and I'm almost there.
Okay, when you park and you're stop moving, we're gonna start your hearing. I just can't expect you to participate in the hearing while you're driving.
Okay.
But as soon as you're stationary, I'm calling this case, okay?
Okay.
Thank you, sir.
Thank you.
Sorry, Mr. Hermes.
It's okay, Your Honor. It's not your fault. Thank you.
210681. This is Country Metals versus Jennifer Cox.
Again, for the record, Your Honor, may it please this honorable court, Matthew Pallets on behalf of the plaintiff. Ms.
And
Cox.
your name?
Pardon me? Can you hear me? Jennifer Cox here.
Ms. Cox, I will indicate for the record before we continue on in this matter, I know Mr. Pallets as an attorney. We're not social friends, but we do know each other from years of practicing in the same courts. Okay. Are you ready to proceed this morning?
Absolutely.
Your Honor, I've had an opportunity to discuss this matter with Ms. Cox. I want to applaud her for navigating the bureaucratic labyrinth in order to obtain some assistance. She has gotten a promise to pay from a HARA affiliate, CBDG. My client has confirmed that they are supposed to be tendering an amount of $1,800. Ms. Cox has also made some attempts to make some partial payments. Ms. Cox has indicated that she may very well be now eligible through the HARA Wayne Metro for the new CERA Coronavirus Relief Act funding that's now been approved by the legislator and the governor, finally. I anticipate hopefully that will materialize within the next 30 days. It's appropriate to do a 30-day adjournment to hopefully explore this option.
Not 30, it'll be 28. 1, 2, 3,
That's fine.
4. April 7th.
At what time, Your Honor?
I'm presuming that Sandy is setting these at 9 o'clock,
Very well.
but the clerk will send notice. Ms. Cox, did you understand everything we said this morning?
So if it's court is on April 7th, I will be back to work by then. So how does that work? Can I is it going to be in the morning or can we do this? Because I start work at 5:30 a.m. and I don't get off until like 4. So I go to lunch at like 11. Or I could just see if my boss will let me get off the floor because I work on the assembly line floor. So I'm not sure how I can do that without taking the whole day off. And
I have no objection allowing her to appear by Zoom, if that helps.
it does. Yes, please, if that's
It is
possible.
it is gonna be by Zoom.
Okay.
The clerks will send notice with an exact time, but Ms. Cox could happen is if you and Mr. Powell reach an agreement, sign it, submit it to the court, neither party would have to appear.
Oh, okay.
Your Honor,
Okay.
may I ask Ms. Cox for some contact information, please?
Sure.
Sure.
Ms. Cox, what is your phone number?
734-693-7976.
7976. And what's your email, ma'am?
It's cox8292@gmail.com.
It's cox8292@gmail.com.
Correct.
Very well. We'll see. We'll monitor the progress of the assistance. Please keep in touch with my client to let them know what's going on. If you are able to obtain anything in writing via email, you can forward that to my client. I would appreciate that and encourage that. In the meantime, we'll try to assess, but the court will tell you that unless we come to a resolution, you are obligated to appear via Zoom on 4/7 at 9 a.m. or whatever court date that they assign.
Anything else, Mr. Pallets?
No, Your Honor. Thank you.
Anything else, Ms. Cox?
I'll get that paperwork with the Zoom information on it in the mail.
Yes, ma'am.
Okay.
Thank you. Have a good day.
You
Mr.
too.
Robinson, did you have a chance to call Mr. Nelson?
No, I was not told to call Mr. Nelson. I was in a breakout room with Mr. Stubbs.
No, when I first pulled you on, I indicated that he was here and I asked you to contact him. Maybe.
Sorry, I was put in a
miscommunication.
breakout.
Your
No
Honor,
worries.
I can handle talking to Mr. Nelson. Do you want us to call him? Is that what you had said?
Would you please? He's in our parking lot and if we don't need to bring him into the building, I'd rather not.
That's fine. Let me just find his paperwork and then get you his phone number for him.
Nope, I'm gonna give you the phone number and you can look for the paperwork.
That's fine. Go ahead.
734-497-8968.
I'm going to put myself on mute and make a call.
Thank you much.
Mhm.
Mr. Visconti, did you have anything ready?
Your Honor, I have one case for Metro Commons with Diane Smith. She failed to appear at the initial Zoom hearing pretrial. It was renoticed for today. I don't see that she's in the waiting room or.
What I'm gonna do. I'm sorry, Mary Ann,
Yes,
would you call Sandy and ask her, did anyone check in on 736, please?
yes,
Thank you.
you're welcome. No, Judge.
Thank you. This is 210736 Metro Commons versus Diane Smith.
Morning, Your Honor. Robert Visconti, P61756 on behalf of the plaintiff.
This matter was scheduled for 9 a.m. It's now 9:35 by the court clock. My secretary has checked with the civil department. No one has checked in on this matter. No one's in our parking lot on this matter. Inasmuch as the defendant has failed to appear this morning, default judgment shall enter. Mr. Visconti, if you would submit that to the clerks, I'll sign it for you.
I'll be happy to. Thank you, Your Honor. Have a good
Thank
day.
you. Have a good day. Mr. Davis, it looks like you're parked now.
Hello?
Hi, are you parked
Hi.
now?
I'm pulling into a parking spot right now. Okay.
Okay. Recalling 210589 NME Group versus Urban Barbershop.
Good morning again, Your Honor. Sean Hermes here on behalf of NME, the plaintiff.
Your name again, Mr. Davis?
Alyssa Davis.
This matter was scheduled for 9 a.m. for a hearing on a complaint to recover possession of commercial property. Are the parties ready to appear this morning?
Yes, Your Honor.
Yes. Are the parties ready to proceed this morning? I don't think that's what I said, though. Are you ready, Mr. Davis? Are you ready to proceed?
Yes.
Please raise your right hands. Do you swear from the testimony you're giving this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. Mr. Hermes.
Your Honor, a lease was signed in this matter on July 1st, 2019 between the plaintiff and the defendant. Plaintiff has failed to make payments pursuant to the lease. The lease was attached, Your Honor, to the complaint, and a copy was provided to the defendant along with the complaint. So the defendant is fully aware of his obligation to pay rent. Attached to the lease was a personal guarantee signed by the defendant, Alyssa Davis. And section 17.1 of the lease specifically states tenant's failure to make payments of rent when due as provided in this lease is this part is not quoted, but is a default of the lease. The section 17 is labeled breach, reentry, and termination, Your Honor. Defendant has failed to make payments for 6 months now. He has a balance of, and I'll have my client confirm this. I'm terrible at math, Your Honor, but I believe the balance of as of today is $12,452.75. Your Honor, this is for a lease that is less than $2,000 a month. So it's been adding up. Your Honor, a notice to quit was sent to defendant, to the Urban Barbershop, and to Alyssa Janelle Davis. 2 different notices to quit, Your Honor. A 7-day notice to quit was sent on 6/12/2020, and a 30-day notice to quit was sent on December 22nd, 2020, Your Honor. So he's been personally served with the complaint. We used one of the court's process servers, and Your Honor, based on the fact that he has not paid rent, we're asking for a judgment in this matter, and a judgment of eviction and a money judgment, Your Honor.
Mr. Davis, your response.
I'm aware that I haven't been able to pay. Unfortunately, my business didn't go as planned with the pandemic. Just to save suit, I'm gonna, if they'll allow me to, I can have everything out by the 1st, and then I can work out a payment plan.
Anything else, Mr. Davis?
No, ma'am.
Mr. Hermes?
Your Honor, my client wants him out as soon as possible, and I know if we get a judgment today, he'll have 10 days. If you'd like, I can go into a private room with my client who's in here, and I can discuss with him if he's okay with allowing him to stay until the 1st, which would be an additional 11 days. So if you'd like to recall the matter, I can discuss it with my client.
I'll do that. I'll recall the matter. I appreciate you taking time to talk to your client. I know that Mr. Davis has to be somewhere at 10 o'clock, so let's just be mindful of time.
I'll make it very quick, Your Honor.
Thank you, sir.
Thank you.
Thank you, Your Honor.
I'll stop talking so you can bring these people in.
Your Honor, it's Matthew Peltz. I have a question for you with regard to Mr. Nelson. Do you want me to tell him to appear by Zoom?
He can. He's in our parking lot.
Oh, do you want me to tell him to come into the courtroom?
Is he still on the phone?
I've got him on hold.
If he is able to Zoom from his car, we would prefer that.
Okay.
It's just because he didn't appear physically the first time, but they've already talked. The officers have already talked to him, so we've confirmed that he's present.
Understood. Okay,
Okay.
I'll give him instruction accordingly.
Thank you.
No, you're not. Can you go back to the Yeah, but I'll put you in the back room and then judge you. Okay. Sorry about that. Thank you.
Mary Ann?
Mr. Robinson, subs are ready.
Oh, thank you. Two one zero seven zero two GNI versus Stubbs.
This is Garrett Robinson on behalf of the plaintiff. Your Honor, Mr. Stubbs and I talked in the breakout room. He's in touch with Wayne Metro, and he was also recently apprised of alternative ways to seek relief for his back rent. So I told him I'd like to adjourn this about a month out, and if it's possible, I'd like to keep it the same date that Mr. Pallett's adjourned his case to. So about April 7th.
Sir with the black shirt on, Mr. Stubbs,
Yes,
could you state your name for the record, please?
James Stubbs.
And you heard the comments made by Mr. Robinson?
Yes,
And is your desire to adjourn this matter for 4 weeks to allow you to continue to seek assistance?
yeah, that's good.
The matter is going to be adjourned to 4/7/2021. I'm going to say right now at 9 a.m. We're not certain of the time. The clerk will mail notice.
Okay.
Anything else, Mr. Robinson?
That's it for this case. Thank you.
Anything else, Mr. Stubbs?
That's all I have.
Have a good day, sir. Thank you.
Thank you.
Mr. Robinson, did you have anything else ready?
I was about to go into the breakout room with Mr. Michael Magis.
Mary Ann's going to send you an invitation. Are we ready for a recall on Urban Barbershop?
I am, Your Honor.
Recalling 210589.
Good morning again, Your Honor. Sean Hermes here on behalf of the plaintiff, NME Group LLC. Your Honor, I had a chance to speak with my client regarding the defendant's offer. We do think it's fairly reasonable. The difference would be, I believe, 11 days extra that he get to stay versus getting a judgment today. So we're more than happy giving him the time until April 1st to voluntarily remove himself. But we're still seeking the money judgment. He did mention that he'll make payments. We can figure that out later, but we are seeking that money judgment, Your Honor. As far as the money judgment is concerned, Your Honor, he owes $12,452.75 in back rent, and we're also seeking the $130 filing fee that was paid. There was a service of process fee of $67 paid, and the statutory attorney fees of $75, Your Honor.
Mr. Davis, did you hear those amounts?
Yes, ma'am, I did.
Are those amounts correct and accurate by your records?
Yes.
Okay. Having heard the parties on the matter and appreciating the plaintiff's willingness to allow until April 1st, 2021 for the defendant to move and vacate the property, judgment shall enter with that move date, as well as a money judgment for $12,452.75 in rent, $130 filing fee, $67 service fee, and $75 attorney fee. Plaintiff will submit that judgment with those terms to the court, and I'll sign it. Mr. Davis, you'll get a copy in the mail. I'll note that Mr. Davis is the only party present on behalf of the defendants. There's another defendant listed by the name of Benjamin Steiner.
Your Honor, I apologize if I have to mention that Benjamin Steiner was not able to be served. So we're only proceeding with the judgment against Urban Barbershop and Alyssa Davis.
Thank you. Anything else, Mr. Hermes?
That's it on our end, Your Honor.
Anything else, Mr. Davis? Mr. Davis?
Well said.
Okay, have a good day. Good luck to you this morning, sir.
Thank you. I appreciate it very much.
Thank you for your time, Your Honor.
Thank
Your
you.
Honor.
The question about the breakout rooms, I don't control them.
Sorry,
If you need to,
Mr. Just
okay.
Mary Ann.
That's okay. She'll put you back in if you need to go back in. What happened with Mr. Nelson?
Your Honor, he said that I gave him the Zoom information. He did say he was going to try and attend. He said his phone was on limited power and he didn't have a charger, but so we'll see.
We can have him come in. It's not a deal breaker.
Okay. Well,
Have you
we'll
already
see.
had a chance to talk to him about the case?
Yes, we did.
Okay,
We have a proposed consent judgment.
let me get him in here.
Okay.
Mr. Pallets, while we wait for him to come into the building, can I put you in a breakout room with Dunn?
Certainly.
Thank you.
Yeah, he just to clarify, he said that he was going to try and appear by Zoom in the parking lot, but he may or may not be able to do that. And then if that's the case, I'll be more than happy to call him back to just tell him to come on in.
Thank you.
But I'll go in the I'll go in the breakout room in the meantime.
Thank you. Mr. Dunn, I'm going to put you in a breakout room with Mr. Pallets, okay?
Okay.
Thank you.
Is there anyone here from Joel Grand's office?
I see a lot of iPhones. I'm going to bring them in. I don't know who they are.
Thank you. I'll let you do what you do.
Okay.
Good morning, Your Honor. May
Good
I
morning.
speak? Yes, I'm an attorney. My name is Haitham Al-Qassi. I'm here on a case, Airport Park Equities versus Sunrise Express. I was waiting, but I have another case with the Macomb County, start at 10, and just want to take your permission to log out. And I don't know how long it's gonna take.
Who do you represent, Sunrise?
Yes.
I don't see an attorney here yet from Airport Park Equities.
Okay, so can I log out and log in like at 10:30 to finish the hearing in Macomb County?
Absolutely.
Really appreciate
I'll see you back
Your
at
Honor.
10:30-ish.
Thank you very much.
No problem.
Hi, sir, or ma'am with the name of iPhone. What is your name, please?
Autumn Halawa.
Miller? Did you say your last name is Miller?
You're on mute, ma'am.
Ma'am, please tell me your last name again. I'm sorry.
Halawa.
Seven 724.
Thank you. Sir, with the name of iPhone, can you hear me?
Yes,
What is your name, please?
Lance Cunningham.
Thank you. Judge, is it okay if I leave them in here and then when the other attorneys come in, I can put them in a breakout room?
Yes,
Thank you.
but that's it, right?
No, can you see who's in the waiting room?
I only see one. Oh, wait a minute.
Yeah,
Sorry.
there's a lot of people in the waiting room.
And oh, see what they talk about first.
See what they're talking about first when they ask you questions, you know what I mean? Like at least a week and a half.
Mr. Pallets, Mr. Nelson is coming into the building in just a second. I'll call that case when he is into the courtroom. I'm looking at our waiting room and we have a lot of tenants here for pallets. So I don't know if you want Mary Ann to admit them and you can take them to a breakout room versus this slow one by one.
How many tenants do you have left right now?
5, I see.
Your Honor, if you don't mind, I think we're doing pretty good of knocking these down one by one, but I'll defer to the court.
No, I'm here.
Okay.
I'm not in any rush.
Okay, so yeah, if you don't mind, we've got an agreement on done, and at least I've talked to Mr. Nelson, so, and I know Garrett is working on another tenant, so.
You have an agreement on 694?
Yes.
Okay.
I just talked to him in a breakout room.
Is he back?
We both.
Yes,
got
I see him.
bounced out.
Nope, I see him. This is 210694 LT Country Metals versus Stephanie and Corey Dunn.
Yes. Your Honor, for the record, again, may it please this honorable court, Matthew Pallets on behalf of the plaintiff.
Your name, sir, after you remove your cap?
My name is Corey Dunn.
And where is the Stephanie Dunn?
She is currently at her place of employment.
Okay.
Your Honor, if I may proceed.
Yes, thank you.
Your Honor, at this time, I've spoken to Mr. Dunn. We are in agreement to enter into a conditional dismissal. We're going to do this not as a stipulation, but as a voluntary conditional dismissal. The tenant, I have explained to the tenant that the amount owed inclusive of court costs and March rent is $1,745.28. He has agreed to pay this by March 31st. We are going to dismiss this on those conditions. If it does not materialize, then part of the terms of the conditional dismissal is that the matter will be reinstated. A judgment and an order of eviction will enter simultaneously without further hearing. I would ask that the court allow us to proceed in this fashion.
Mr. Dunn, did you hear what Mr. Pallett said this morning?
Yes,
You understood that?
I did.
And you want to agree that you will pay $1,745.20 by March 31st, understanding that if you pay by that date, the matter will be dismissed?
Yes,
And that if you fail to pay by that date, the case will be reinstated and judgment shall enter against you?
I understand.
Okay, thank you. Mr. Pallets will submit the conditional dismissal to the court electronically. I'll sign it. You'll get a copy in the mail. Anything else in this matter, Mr. Pallets?
No, Your Honor. Thank you.
Anything else, Mr. Dunn?
No, thank you, Your Honor.
Thank you, sir. You have a great day.
You too. Thank you.
Thank you. Mr. Bolton. You just missed the attorney for Sunrise Express. He had a case in Macomb. He said he will call back at 10:30. I love that you're smiling in response to that.
Well, I actually have a 10:30 in bankruptcy court. So when he calls back, can we do it at it's a 3:41, so it should be over quickly, like 11 maybe.
When you're done with your 341, come back. When he comes back from Macomb, I'm going to hold him here.
Okay. I can probably do it. I can try to do it simultaneously too.
I love how inefficient we are when we try to do 2 Zooms, but go do your 341. When you come back in, like I said, I'll call the case and we can figure it out.
All right, thank you, Your Honor.
Thank you, not a problem.
All right.
Have a good day. Is Mr. Robinson back or Mr. Pallets? They're both in breakout rooms. Mr. Nelson's here and I want to call the case because he's physically in our courtroom. Good morning, sir. You had an opportunity to speak to. I was listening to my secretary. You've had an opportunity to speak to the Palace Law Firm. Are you ready to proceed this morning? Okay, I'm going to ask you to cover your nose, please. And I'm going to have you come up to this table only because I'm going to need to be able to pick you up. This first table right inside this gate. Come on the other side because the mic is not going to help, but you're good right there. You can just stand right there. Stand because it's picking up from my laptop. So I want to be able to have them hear you. Mr. Robinson, can you proceed on Charles Nelson or do we need Mr. Pallets?
I believe Mr. Pellets is the one who was talking to him, so.
Okay. You can go back to your breakout room. I need Mr. Pallets. Is it that you can't Zoom?
My phone was at 75% when I left the house and I've just been waiting. It wore down. So I tried to sign into the meeting and it made me download the app and now.
It's fine. It was just because you didn't appear for the first hearing that they scheduled for you for in person this time.
Okay.
And the attorney is in a breakout room, but as soon as he comes out, we will call the case. There's nothing else ready. So as soon as he comes out, get you going so we can get you back to your car and back on your way. I'm sorry, I saw you come in and I started right up and I don't think I said good morning or asked you how you were.
Oh, good morning. I'm okay. A little nervous.
No, don't be nervous. It's just the 3 of us.
Okay.
Hi, the person with the name of Whitney, can you hear me?
There's nobody else in the parking lot, I'm guessing.
There were a couple of people.
The person with the iPhone, can you hear me? Person that looks like they're sitting in a car, can you hear me?
Having way too much fun, Mr. Nelson.
Sir, can you hear me? Good boy.
Back to the waiting room. I don't know where Mr. Pallets is.
Do you want me to have them?
I need just Pallets so I can send Mr. Nelson back. Mr. Pallets can go back to the breakout room afterwards. Friday, we have arraignments. I don't know if I told you that.
Yeah.
Okay.
Good morning.
Listen, if you bring Mr. Robinson on again, is he done?
I believe.
Nope, here we are. 210673 LT Metals versus Charles Nelson.
Your Honor, for the record, may it please this honorable court, Matthew Pallets on behalf of the plaintiff.
Your name, sir?
Charles Nelson.
I don't have my in courtroom camera set up, but Mr. Nelson is here physically in the building. He's unable to download Zoom. Mr. Nelson, you weren't in when I indicated to the audience previously that I know Mr. Pallets as an attorney to attorney in other courtrooms. We have no social relationship. Okay, you've had an opportunity to speak with him this morning, and you're ready to proceed. The parties, what are we doing, Mr. Pallets?
Your Honor, I have had an opportunity to speak to Mr. Nelson about this matter. For the record, he has tendered a CDC declaration. He is attempting to try and get assistance. Right now, he's still making those attempts. I did go over the amounts that are owed currently, which is rent to retain of $7,009.96, court costs of $158, for a total of $7,167.96. He does acknowledge that that is the amount owed. However, again, he is trying to get assistance. Regardless of that, in light of the fact that the amount's owed and he has not obtained this assistance yet, it would be appropriate for us to enter into a judgment today that's reflective of that amount. The writ date would reflect the CDC declaration date as it is in law as right now, which would be March 31st. I did explain to Mr. Nelson that he should continue to keep a dialogue with my client, and perhaps he might be able to obtain assistance. Perhaps there might be some agreement that they might be able to enter into. But as far as today goes, it is appropriate to enter into a judgment today with the amount is paid for on the record. I would ask that it be taken.
Is this a consent judgment?
Your Honor, I would ask that it be entered as a consent. I did explain 4.2012 to Mr. Nelson. I would ask that you ask the defendant if he does so concur.
Mr. Nelson, were you able to hear the amounts that the attorney just placed on the record as due for rent and for cost? Are you in agreement with those amounts?
I try to get money from heirs. And they say they $1,000. Country Meadow says
$2,000 is in dispute.
Your Honor, if I may, it's not that it's in dispute. He did apparently apply for $2,000 for some sort of government assistance. It was some time ago. I'm making the leap that was part of the prior EDP program that has since expired. My client has never received any promise to pay nor monies from EDP or Wayne Metro, the HARA. So it's not in dispute other than that he's trying to get assistance for it. And it does not have, as far as an impact, as far as the amounts owed that I've articulated on the record. So that's, again, to clarify, I've explained to the tenant that it's ultimately his responsibility to see if he can track down that payment.
But if there's a dispute as to the amount owed, and that's what I'm hearing from Mr. Nelson.
Well, Your Honor, if I may address that, he's not disputing the amount. He's not disputing that.
Mr. Pallets, give me 1 second.
Certainly.
Are you you're disputing the amount, $7,009?
I do owe that.
Okay.
It should be $2,000 last. Wayne County Cares that told me they sent the Country Meadow.
There's two different things. Mr. Palace has put the amounts due on the record and said that a judgment should enter. And when I asked him, was that by consent? That means, do the parties agree that these are amounts that are owed and the court can sign the judgment? But if you're telling me no, that this $2,000 is in dispute, we'll have a hearing, I'll swear you in, and we'll take testimony. That's why I'm asking you. I hear Mr. Palace and I understand what he's saying, but I'm asking you, the Wayne Cares money is at issue.
Is that issue? They told me that Country Meadows has to call them and figure out where the money is.
Your Honor, I did hear that. May I respond?
Yes.
Respectfully, that's not the responsibility of my client. That's the responsibility of the tenant to obtain those fundings. I can tell you, and we can bring my client in and we can have a hearing, but at the end of the day, the testimony that's going to be offered is that they have not received any monies from the Wayne Metro, and it's ultimately the tenant's responsibility. So although he's disputing that it's been paid on his behalf, he's not disputing that it's owed constructively.
Mr. Nelson, do you have any documentation regarding the payment from Wayne Care?
Emails.
You have emails that say that they tendered $2,000 to Country Meadows.
I talked to them on the phone 2 or 3 times. So the park manager told me that Cares figure out where this money is.
But you're the one that applied for the,
Yes.
okay.
Yes, I am.
Do you have any defense to the payment of rent?
Other than that, I had gotten my hours cut and laid off when this was all going on at the beginning, and that's.
Okay. Mr. Nelson, I hear what you're saying. I've listened to Mr. Palace as well. Unfortunately, well, not unfortunately, that's a poor choice of words. In as much as you don't have a defense to the amount of $7,009.96 with $158 in costs, the court is going to enter judgment in that amount. It will not be by consent because it doesn't sound as if you're agreeing to it. But if Mr. Palace office submit the judgment, the court will sign it with the understanding that you have a CDC declaration form in place. Which means that there is no additional action that can be taken by the plaintiffs at this time. What I would suggest to you is, in as much as you're the person who applied for Wayne Cares, you can follow up with them, or if you have emails that can confirm that that amount was transmitted, you can supply either a check number or some kind of transfer information to Country Metals. They might be willing to look into it, but I can't make them. And because you're the one that applied for the assistance, you should be the one that follows up. Okay.
If I continue to try and they say that.
Okay. Anything else, Mr. Palace, as relates to Mr. Nelson?
No, Your Honor, thank you.
Anything else, Mr. Nelson? Thank you, sir. Have a good day. Watch the mail. He'll submit the judgment. I'll sign it. The court will mail you a copy.
Okay, and then I'll get it, there'll be another court meeting after the 31st.
No, sir.
Okay.
The judgment is the final order that enters in this matter. Okay?
So this is one on my record
As of when I signed the judgment. Okay?
Okay.
Anything else? Have a good day.
Actually, I just after the 31st, then we get something in the mail saying haven't found funding.
No, what'll happen is if you are not paid or moved, right, non-payment case, if it's paid, then you stay. If it's not paid, they can file a request to have you removed from the property. So what I suggest, again, follow up with Wayne Cares. If there are any other resources available to you, either through DHS or Wayne Metro or some other agency.
Okay.
Those numbers would have been on the yellow sheet you received when you got summons and complaint originally. Okay?
Okay. I can't get any funding. The 31st, something comes in the mail. And
I don't know that that's what they do. I don't know how they send notice of the eviction. Okay?
Right, well, so just keep in contact with the clerk and watch the mail.
Yes, sir. Anything else? Thank you, Mr. Nelson.
Thank you.
Have a good day. You can go, nope, you can go right back out the way you came. Mr. Robinson, you were ready with Mr. Negus?
As wet as we can be, yes, Your Honor.
Oh, see, that's not the right answer. Sorry. 706. This is 210706 LT GNI versus Michael Megas.
Garrett Robinson appearing on behalf of the plaintiff, Your Honor. So Mr. Megas and I have talked a number of occasions, both last hearing and today. He is currently unwilling to pay his back rent. He has indicated that he does not think that the apartment is enough of an upgrade, and thus is withholding his rent. He also indicated that he would like to pay by a money order because it's behind in his rent. His manager is all right with him paying by money order, but he still indicates that he does not want to pay the full amount. In particular, things like the court costs. In light of his failure, in light of his refusal to pay his back rent, I would ask for a judgment in this matter.
So the answer to my question is that you're ready to proceed and you need a hearing.
Yes.
Okay. Mr. Meekins, were you able to hear what Mr. Robinson just said on the record?
Yeah, I've heard him loud and clear, Your Honor, and I apologize for all this.
No, no apologies necessary.
Oh, but everybody's got a side to a story, and I've heard his. You know Judge Donald Coleman by chance, 36?
I do.
He's a great friend of mine, and he's also now my pastor. Only God can orchestrate my story, and he's been listening to it every inch of the way. He knew I was homeless. He sees what God has done for me. But then you get the enemy. You know, the enemy comes in and tells you all these lies. Oh, you're going to have a brand new apartment where from the drywall up. I'm in construction. Just so happen to own my own drywall company. This place is not from the drywall up. I've had issues. I wanted to pay my rent from day one. Understand this. I've not wanted to pay my rent, but I was forced to go to email, which I don't email. I was also forced to try to download an app from Habitat to pay this online. I understand COVID's been a challenge for everybody, but is this more about control than it is? Because to try to control me, I'm not looking for that. You know how I moved in? They told me, well, why don't you just pay how you moved in? I go, great, I'll go get a money order, because that's how I paid to move in. Now they want me to do everything online. Your Honor, I've got the money in escrow, and I don't even feel this place is worth $1,180. I could have went with the no upgrade for $850 and been just as satisfied as I am with this. I've been lied to. Other people, unfortunately, are 78. You know, they've been really bamboozled. And I hear it from a lot of people, and I don't want to be the spokesperson for everybody. I'm just trying to plead my case.
Mr.
Now
Meekins?
now that I've lived here for 4 months, I'm happy with it, but I'd like to pay. I want to pay. I'm sorry. Go ahead, Your Honor.
You have me at a disadvantage because what I have in the file is a demand for possession that indicates that you owe $2,807.34 as of January 7th, 2021. I have the verification regarding CDC eviction moratorium declaration, a copy of the summons, copy of the complaint, proof of service, and the notice of hearing for today. So this information you're giving regarding upgrades and making payments, I don't have any of that. So if you are in dispute with your landlord regarding how much is due, we need to have a hearing in this matter.
Well, that's fine. Yeah, I'm in this because my door wall don't close, and I'm getting older, and it's very difficult. If they had a handle, I do this every day, Your Honor, and I work in $6.5 million home. One of them was the CEO of the Pistons. I'm an honest as the day is long, but I'm tired of everybody lying to me these days. You're not one of them, trust me. It's just these people, you know, they got to get people to move in, so they tell them what they want to hear, but they don't deliver.
Mr. Robinson, I'm sorry, Mr. Robinson, are you aware of the issues that he's raising?
Yes,
he has raised certain issues with it. He has talked about a dishwasher is broken, but the dishwasher that's now fixed. He's talked about a washer dryer being old, but not that don't work. As far as I know, that there's no real question about the habitability of the home. He simply doesn't like the age of the appliances in the home.
Well, they didn't deliver what they said they were going to deliver. I was supposed to.
And Mr. Meekins, no. My issue and my concern is, as I indicated, I don't have a copy of the lease, so I don't know what agreements exist between the parties. I hear this information about needing to download an app and being requested to make payments in certain ways, but I don't have anything that says exactly how payments are supposed to be made. So my question is, if the parties do not have an agreement and you need to have a hearing, are you ready to proceed this morning?
If the manager is not here immediately, I can give him a call and ask him to log on, Your Honor.
And documents would come how? And Mr. Meekins, your information regarding your repair request and sounds like you're making a request for offset regarding the rent.
Well, yeah, the rent, you know, like I said, I mean, I understand. I'm in construction and I deal with it every day, and I wouldn't want my name. If I could just walk, I went next door.
I'm sorry. Maybe I didn't say my question as artfully as I should have.
Yeah,
witnesses and documents to proceed with the hearing this morning. Are you ready?
I'm ready. Yeah, I'm ready to go. I mean, like I said, I've been willing to pay this from day one, but I don't want to be forced into something. And now on top of that, all the stuff. I mean, I had stinky water in my dishwasher for a month and a half.
Your Honor, is there an email to which I could have the manager send documents. If it's not immediately available, we could adjourn this out for a week and just come back to this in a very short amount of time.
I want to pay my rent, trust me. I just want what's fair. I'm fortunate I can pay my rent, Your Honor. A lot of people can't.
Mr. Meekins, every time you start talking, I can't ask her to look on my calendar and see what's going on next Wednesday.
I'm so sorry.
That's
so
okay.
sorry.
I know you're not here, but can you see what's going on 17? I'm sorry, I'll be right back.
Hallelujah. Nice view though, man, really, I mean, that's about it, I like my view better.
You're good, Judge.
Thank you. I'm just looking at the other. St. Patrick's Day, right? March 17th, at what time? Morning or afternoon? Mr. Robinson, what does your schedule look like?
Let me look at it's still pretty open on 17th, so morning or after. I would prefer the morning personally.
Dominguez, are you okay with
Yeah, I'm okay with anything. I really am. Thank you.
March 17, 2021 at 9 a.m. back with me?
All right.
There are documents that you want to submit to the court.
I'm sorry, March 17th, what was that time again, Your Honor?
9 a.m.
9 a.m., I got it. All the same.
Witnesses and documents.
Your Honor, it's Matthew Pellets. Do we have contact information for Mr. Migas?
No, I do not believe we do, Matt.
If we could have a phone number and email so that we can send him our exhibits.
Please do not send me an email. I'm trying to explain that to people. I am not an email man, so I've got 50,000.
It's the way we have to send.
No. What we're going to do, however Pallett's law firm submits documents to the court electronically, you can submit the court's copy that way. And as much as Mr. Migas is a tenant of your client, I'm sure they can find a way to get the documents to him. How's that?
That's
if you're
fine,
not an
Your
email
Honor.
person, I'm not going to make you.
Understood, Your Honor. Do we have a phone number for Mr. Migas?
God bless you.
Mr. Migas, your phone number, please.
734-444-9924, Your Honor.
Documents and witnesses. I will see you next Wednesday at 9 a.m.
Thank you. God bless you. Have a wonderful
Thank you.
You're welcome.
Yeah, this is not how it started off. So, Ms. Boyd.
Yes, Your Honor.
Are we ready?
We are, Your Honor. We have a consent judgment on this matter.
Two 10715 G&I versus Benicia?
Yeah, that's Benicia.
Benicia, thank you, ma'am. Boyd.
No problem.
Your appearances.
Yes, Your Honor. May it please this honorable court, Matthew Pallets on behalf of the plaintiff.
State your name, ma'am, please.
Benicia Boyd.
Thank you.
Your Honor, if I may proceed.
Thank you.
Your Honor, Ms. Boyd and I have had an opportunity to discuss this matter. We do have a proposed consent judgment. I did explain to her the rent to retain is $4,957.20, court costs of $167, for a total of $5,124.20. Ms. Boyd is attempting to seek hardship through her 401k and obtain monies through that way. She does need some additional time to obtain those funds. We have since agreed to a consent judgment with a writ date reflective of March 29th to allow her to accomplish that. I did explain MCR 4.201 to her. I would ask that we enter this consent judgment. I get her permission to sign the judgment via Zoom consent.
Ms. Boyd, you heard the comments made by Mr. Palace this morning.
Yes.
You acknowledge that you owe rent of $4,957.20, and there have been court costs of $167 for a total of $5,124.20.
Yes.
That you will pay this amount by March 29, 2021, or be prepared to move.
Yeah, that's fine.
And you understand,
yeah.
you understand that the attorney is going to submit a judgment to the court. He has asked for your permission to sign your name to that consent judgment. We have your consent?
Mm-hmm.
I need you to say the word.
I'm sorry. Yes, Your Honor.
You're fine. Mr. Palace will prepare the consent judgment, send it over to the court. I'll sign it. You'll get a copy in the mail.
Okay.
Anything else, Mr. Palace?
No, thank you, Your Honor.
Anything else, Ms. Boyd?
No.
Have a good day, ma'am. We're all set.
Thank you.
Thank you.
Mr. Cunningham, are you there?
Yes, Your Honor.
Hi, Mr. Cunningham, I'm going to put you in a breakout room with Mr. Pallets.
Okay.
Thank you.
Are all of these pallets people?
Mr. Banks and Miss Nichols, can you hear me?
Yes, I can hear you.
Hi, Mr. Banks, can you hear me?
He's in. He might not hear you. I think there
okay.
was a connection problem.
Okay, as soon as the attorney comes back on screen, I'm going to put you in a breakout room with them, okay?
Hello?
Okay.
Hi, Mr. Banks. As soon as the attorney comes back, I'm going to put you and Miss Nichols in a breakout room with him, okay?
Okay.
Thank you.
What I have not seen still is anyone from Joe Grand's office. This is 210733 LT Trilogy Apartments versus Chadrick Stanfield. This matter was scheduled for 9 o'clock. It's now 10:23 by the court's clock. Neither party is checked in. Not the attorney for Trilogy or Chadrick Stanfield or J.C. Porter. Inasmuch as no one has appeared, complaint will be dismissed. I never saw. That's it. Our waiting room is empty, correct?
Hi, ma'am. Can you hear me? Who just sat down?
Ma'am with the striped top on, Jennifer,
Yes,
what are you here for this morning?
representing Airport Park Equities versus Sunrise Trucking with Ian Bolton.
I haven't seen the attorney for Sunrise appear back from his Macomb hearing.
Okay.
So if you sit tight, I'll call it when the attorney comes back.
Yeah, I think they said 10:45, so I'm just waiting here till then.
Okay, thank you, ma'am.
All right, thank you.
Are you ready on Hollowell and Chalmers?
Yes, we are, Your Honor.
Yeah, I can be ready on that. Yeah, we were closed out a little bit prematurely, but we're ready to go.
210724 GNI versus Hollowell and Chalmers.
This is Garrett Robinson on behalf of the plaintiff. Ms. Hallowell and Mr. Chalmers recently made a very large payment. They still have a significant back balance, but they're applying for they applied for aid from, I think, DHHS, but they're also going to apply for SARA funds when those become available. I directed Ms. Halliwell to Wayne Metro's number. So I'd like to adjourn here to the 7th to give her time to make those applications.
Ma'am, you heard the comments made by Mr. Robinson this morning,
Yes, Your Honor.
and they're accurate.
Yes, ma'am.
And you'd like to adjourn this matter till April 7th?
That would be amazing. Yes,
Matter will be
please.
adjourned. Matter will be adjourned to April 7th, 2021. I'm gonna say at 9 a.m., but the clerks will send you notice if the time changes, okay?
All right, thank you, thank you.
Before you go, where is Nicholas Chalmers?
I am right here.
Thank you, sir.
Yeah.
Anything else, Mr. Robinson?
That's it in this case, Your Honor.
Anything else, Ms. Chalmers?
No. No,
We're
Your Honor.
all set. Thank you much.
All right, thank you, thank you.
Mr. Robinson, do you have a list of the outstanding files this morning?
Yes, I do.
I just I want to get rid of what I can get rid of. Are you waiting? Or do you have something else ready? I guess I should start with that.
Your Honor, if I may, I've got one that's ready for a consent judgment. And then we can go through the list of all the files if you like.
What do you have?
I've got Cunningham 21-0713 LT. We got bounced out of the waiting room, but my client has accepted his offer, so we can put it on record.
2-1. Where's Mr. Cunningham? Oh, we were so close. And people were I saw him and then he disappeared.
Hi, can you leave the breakout room and go back to the main room, please?
Marianne, you must have some plush couches or something in there that they insist on staying in the breakout room. Nice hookah lounge or something, I don't know.
Okay, I'm back, Your Honor.
This is 210713 LT G&I versus Lance Cunningham.
Your Honor, may it please this honorable court, Matthew Pallets on behalf of the plaintiff.
Mr. Cunningham,
Yes, Your Honor.
turn your video on for me, please.
He said that he was having difficulty.
Yeah, my setting is saying I won't let me enable my camera. Unable to access my camera for some reason.
Mr. Cunningham, what's your apartment number?
205.
Thank
building.
you. Mr. Pallets.
Your Honor, again, may it please this honorable court, Matthew Pallets on behalf of the plaintiff. Your Honor, I've had an opportunity to discuss this matter with Mr. Cunningham. I did go over the amounts of rent to retain, which is $2,635.61. Court costs of $167 for a total of $2,802.61. Your Honor, the defendant had proposed a payment date of March 31st. I've talked to my client. They have approved that. So the writ date will reflect March 31st. I would ask that a consent judgment be entered as prayed for, and I would ask Mr. Cunningham to give us consent via Zoom to sign his name to said judgment.
Mr. Cunningham, you heard the comments made by Mr. Pallets this morning.
He's attempting his video apparently.
With a Roots sweatshirt on. I haven't seen that in a long time. Mr. Cunningham, you heard the comments made by Mr. Pallets.
No, I didn't hear. Your Honor.
But what Mr. Pallets said is that there is rent due and owing right now of $2,635.61. that there's court costs of $167, which totals $2,802.61. That you had an opportunity to speak with him this morning, and that the parties are in agreement that that is the amount that is owed, and that you will pay that amount or move by March 31st, 2021. Is that your understanding?
Yes, Your Honor.
And you wish to consent to that amount and that date?
Yes, Your Honor.
What typically happens is the plaintiff sends over a consent judgment. What Mr. Palace asked was your authorization to sign your name to the consent. Do you agree to have him sign your name to that document?
Yes, Your Honor.
Thank you. And you're entering this consent voluntarily?
Yes, Your Honor.
What will happen then is the court will await Mr. Pallett's submission of that document with the party signatures. I'll sign it and the clerks will mail a copy to you, okay?
Okay.
Anything else that relates to Mr. Cunningham, Mr. Pallett?
Your Honor, I just would say that I did not have a chance because we got bounced out of the breakout room, but pursuant to MCR 4.201, I would explain to Mr. Cunningham that since he does not have a lawyer present, if there's been a misunderstanding in the law, he has 3 business days from today's date to file a petition for the court to set this consent judgment aside should he have cause to do so, and 10 days to appeal.
You understand that, Mr. Cunningham?
Yes, Your Honor.
Any questions, Mr. Cunningham?
No, Your Honor.
We're all set. You have a great day, sir.
You too.
Thank you. Did you need to go back into a breakout room, Mr. Pallett?
Are there any tenants still waiting breakout room, Marianne?
No, sir.
Okay.
You mind going through the defaults with me until Mr. Robinson comes back? Oh, he's back.
Absolutely.
Doesn't matter. This is 210664 LT Van Buren Estates versus Scott Turner. This matter was scheduled for 9 a.m. It's now 10:33 by the court's clock. The defendant having failed to appear, default judgment to enter. Which one of you wants to provide the amounts?
I'll take care of that, Your Honor.
Thank you.
Your Honor, again, for the record, may it please this honorable court, Matthew Pallets, on behalf of the plaintiff, yes, in light of the fact defending him failed to appear as for default judgment, possession only be taken. Amount of rent retained is $1,198.96. Court cost of $166 for a total of $1,364.96.
Again, this matter having been scheduled for 9 o'clock, it's now being 10:33 by the court's clock. There's no one in the court's virtual waiting room. Default judgment shall enter the amounts provided by plaintiff's attorney. Plaintiff's attorney shall submit that judgment electronically and the court will enter it. I see someone here, Ms. Nichols.
Yes. Can you hear me, Judge?
I can hear you. I'm sorry, I was just looking for your file. Have you had an opportunity to speak to either Mr. Palace or Mr. Robinson this morning?
We did speak.
Yeah, we were just in the breakout room with him.
Were you ready to proceed or did you need to go back into the breakout?
I believe we can proceed, Your Honor.
Anderson's raising their hand. Why?
Because I didn't talk to you yet.
You'll talk to me in just 1 second. I'll get to you.
Okay.
Thank you. 210723 G&I versus Sharon Nichols.
This is Garrett Robinson on behalf of the plaintiff. Your Honor, I talked to Mr. Nichols and Mr. Banks, who is here. He's just muted. I'd like to enter a consent judgment to vacate the premises by April 7th, 2021.
Ms. Nichols?
Yes.
You heard the comment made by the attorney?
Yes.
And that's what you'd like to agree to?
Yes.
And Mr. Banks?
He
went to the breakout room. That's okay.
There he is. It's back.
Hello?
Mr. Banks,
Yes, ma'am.
turn your video on for me, please.
My camera is broken. This is my only way.
It's okay. I called the case and Ms. Nichols and Mr. Robinson put their appearances on. Mr. Robinson has indicated that you will vacate the property by April 7th, 2021.
Yes, ma'am.
That's your agreement and your understanding?
Yes, ma'am.
And the plaintiff's attorney will submit a judgment to that effect?
I will indeed, Your Honor.
Are you going to send it to the defendants for signature, or are you asking them to allow your signature?
Your Honor, I'd appreciate permission from Ms. Nichols and Mr. Banks to sign on their behalf. Do I have your permission, Ms. Nichols and Mr. Banks?
Yes.
Ms. Nichols,
Oh, yes, sorry.
thank you.
That's okay. That's one of the reasons why I wanted you to have your camera on, Mr. Banks, because we are talking about you moving from the property by April 7th, 2021. But in as much as both defendants have given their verbal permission to plaintiff's attorneys to sign the consent judgment on their behalf, the court will await submission of that judgment indicating that the parties will move by April 7th, 2021. I will then sign it and the copy will be mailed to the defendants at their address of record. Anything else in this matter, Mr. Robinson?
That's it for this one. Thank you, Your
Anything
Honor.
else, Ms. Nichols?
No. Oh wait, I do have one question. Okay, so being that we will be vacating the premises, is there any way that we can set up a payment arrangement to have that back paid rent still paid back? Because I just started a new job, and then Deshaun, he starts a new job as well. So we're working on getting the money paid back.
I'm sure that you're, frankly, Ms. Nichols, I'm sure that your landlord would appreciate whatever you were to do to pay, but with a consent judgment to vacate, the case will be dismissed on your leaving the premises.
Okay.
Instead of
Okay.
paying the back rent.
Okay.
I'm sorry, you said the case will be dismissed upon them vacating the premises?
Sorry, sorry.
Well, that was
There'll be, there's, yeah, I'm sorry, I was thinking of a conditional dismissal, Your Honor. Right, but the judgment here, the consent judgment here, Ms. Nichols, is that you're leaving instead of paying. Does that make sense?
Yeah, it does. I'm sorry.
Okay.
My connection is messing up.
Your Honor, if I may, this is Matthew Palace. I'm co-counsel on this matter. Ms. Nichols, just to answer your question further, although the proceedings today, you've agreed to a voluntary move out. As far as paying the back rent, you still may owe that. So you should get in touch with our client to see if they will make arrangements for you to pay the back rent upon move out, okay?
Okay, that's fine. I've been in contact with them anyway, so that makes
Very
sense.
good.
Thank you.
Very good.
Thank you.
Okay.
Anything else, Ms. Nichols?
No, that's it.
Have a good day, ma'am.
Thank you.
I see that the gentleman is back from Monroe, but don't bring him in just yet. I want to get done what I can get done with pallets. 210. Oh, Anderson, I'm sorry. 210718 G&I versus Anderson.
Matt, did you talk to Ms. Anderson?
I have yet to talk to Ms. Anderson. Your Honor, may Mr. Robinson go in a breakout room with Ms. Anderson?
Ms. Anderson.
Yes.
You're going to see an invitation to go into a breakout room with the Pallets Law Firm. Please take that invitation, talk to them, and when you come out, I'll call the case, okay?
Okay.
Thank you, ma'am. This is 210670 LT Country Metals versus Lawrence Smothers. This matter was scheduled for 9 o'clock. It is now 10:39 by the court's clock. I have not seen the defendant check in this morning, and they are not in our virtual waiting room. Mr. Pallets?
Your Honor, may it please this honorable court, Matthew Pallets on behalf of the plaintiff in light of the fact defending having failed to appear. As for default judgment for possession only be taken at this time. Amount of rent retained is $927.08, court costs of $158 for a total of $1,085.08. Thank you.
I made a note in the file, default shall enter, plaintiff's attorney to submit judgment. Anything else in this matter, Mr. Pallets?
No, Your Honor, thank you.
Thank you. This is 210674 Country Metals versus David Miller. This
Your Honor,
matter was scheduled. This matter was scheduled for 9 o'clock. It's now 10 by the court's clock. Mr. Pallets is present. Defendant has failed to appear as of 10:40 a.m. There is no one by that name in the court's virtual waiting room. Mr. Pallets.
Your Honor, in light of the fact defendant having failed to appear, ask for default judgment be entered at this time. Amount of rent to retain is $2,343.86, court costs of $158, for a total of $2,501.86. Again, ask for default judgment possession be taken.
Inasmuch as defendant has failed to appear, is not in our virtual waiting room as of 10:40 a.m. Default judgment shall enter. Plaintiff's attorney shall submit a judgment as reflected on the record. Anything else in this matter, Mr. Pallets?
No, Your Honor.
This is 210686 Country Metals versus Corey Volkman and Kelly Orbis. This matter was scheduled for 9 o'clock this morning. It is now 10:41 by the court's clock. Neither defendant has checked in this morning. There's no one by either of those names in the court's virtual waiting room. Mr. Pallets is here, sir.
Your Honor, in light of the fact defendants having both failed to appear, ask for a default judgment possession only be taken. Amount of rent to retain is $584.64, court costs of $176, for a total of $760.64. Again, ask for a default judgment is prayed for.
Inasmuch as neither defendant appear for this duly scheduled matter, default judgment shall enter containing the terms placed on the record by Mr. Pallets. Anything further in this matter, sir?
No, Your Honor, thank you.
Thank you. This is 210687 LT Country Metals versus Christine Tucker and Stephen Tucker. This matter was scheduled for 9 a.m. It is now 10:42 by the court's clock. There is no one in the court's virtual waiting room with the name Tucker. Inasmuch as the defendants have failed to appear, Mr. Pallets being here, Mr. Pallets.
Yes, Your Honor, may ask for default judgment be entered at this time in light of the fact defendants having both failed to appear. As rent to retain is $1,967.13, court cost of $176, for a total of $2,143.13. Again, ask for default judgment is prayed for.
Plaintiff having appeared, both defendants having failed to appear as of 10:42, default judgment shall enter in the amount placed on the record by plaintiff's attorney to submit the judgment reflective of these terms. Anything else in this matter, Mr. Pallets?
No, Your Honor, thank you.
Thank you. 210693 Country Metals versus Matthew Haney and Justin Haney. This matter having been scheduled for 9 a.m., it now being 10:43 by the court's clock. There is no one by the name of Haney in the court's virtual waiting room. Plaintiff's attorney has appeared. Mr. Pallets.
Your Honor, in light of the fact both defendants having failed to appear, as for default judgment possession only be taken, amount of rent to retain is $3,206.96, court costs of $176, for a total of $3,382.96. Again, ask for default judgment be entered as prayed for.
This matter having been scheduled for 9 o'clock, defendants having failed to appear as of 10:43 a.m. Default judgment shall enter in favor of plaintiff and against defendants as placed on the record by plaintiff's attorney. Anything else in this matter, Mr. Pallets?
No, Your Honor, thank you.
Thank you. I see that Mr. Robinson and Ms. Anderson are back. Are the parties ready in this matter?
Yes, Your Honor.
This is 210718 G&I versus Anderson. Your appearance, please.
This is Garrett Robinson on behalf of the plaintiff. All right, Your Honor, I talked to Ms. Anderson. She's applied for aid from DHHS and believes that they're ready to pay very quickly. She also has about half her balance ready to pay on her behalf. And we'd like to, so we'd like to enter a consent judgment to pay by April 7th, 2021. And I can give you, well, to pay the figures, the following figures. Rent to retain of $5,160.17, costs of $167.00 for a total of $5,327.17.
Ms. Anderson.
Yes.
Could you state your name for the record, please?
Jontasia Anderson.
What's wrong, ma'am?
Can you hear me?
I can hear you. I just couldn't see you.
Oh. Oh.
Did you hear the attorney this morning?
Yes.
He's indicated that there's rent of $5,160.17, court cost of $167, for a total of $5,327.17. He's further indicated that the parties have agreed that that amount will be paid by April 7th, 2021. Is that your
Yes.
understanding?
Yes.
And that's your agreement?
Yes.
What'll happen is the plaintiff's attorney will submit a consent judgment to the court with those terms.
I am ready to do so, Your Honor, and I'll get that to you today.
Thank you. Ms. Anderson?
Yes.
Is Mr. Robinson signing your name to this consent judgment?
Yes.
He has your permission.
Yes.
Thank you.
Thank you, Your Honor.
He'll submit the consent judgment, the court will sign it, you'll get a copy in the mail. Anything else, Ms. Anderson?
No.
Thank you for your patience this morning, ma'am. Have a good day.
You too.
Thank you. 210695 Country Meadows versus Gloria Church and Tabitha Carr. This matter was scheduled for 9 a.m. this morning. There is no one in the court's virtual courtroom with those last names. Matter was scheduled for 9 a.m. It's now 10:47 by the court's clock. Defendants have failed to appear. Mr. Pallets or Mr. Robinson?
I'll take care of this, Your Honor. And again, for the honorable court, may it please the court, Matthew Pallets on behalf of the plaintiff. In light of the fact defendants having failed to appear, on rent to retain is $4,669.27, court costs of $176, for a total of $4,845.27. Ask for default judgment is prayed for.
Inasmuch as the defendants have failed to appear as scheduled this morning, default judgment shall enter with the terms placed on the record by a plaintiff's attorney. Anything else in this matter, Mr. Pallets?
No, Your Honor. Thank you.
Thank you, sir. 210697 Green Meadows Apartments versus Jaslyn Seaborn. I saw Miss Seaborn this morning.
Right there still.
I'm sorry?
She's trying to connect to the audio.
Garrett, did you have a chance to talk to Ms. Seaborn?
I have not yet.
Okay,
She's been trying to connect all morning.
I know, I've seen her. That's why I was putting it on the side. If she's able to connect, or Marianne, can you try to move her and Mr. Robinson into a breakout room?
Yes.
I see half of the people back for that Macomb hearing. I'll get to it when I get to it. This is, what happened with Lakeisha Humber? 210710.
Your Honor, who's the plaintiff on that?
You, D&I.
I'm sorry, who? Oh, yeah.
I don't have the file anymore, so I'm just curious if the case was resolved some other kind of way.
Your Honor, Gary, well, he's gone. I have not spoken with this tenant.
I don't have the physical file. Let me,
Okay.
I'll get back to it. This is 210711 G&I versus Porsche Howard. This matter was scheduled for 9 a.m. It's now 10:49 by the court's clock. There is no one in the court's virtual waiting room by that name. Mr. Pallets.
Your Honor, in light of the fact defendant having failed to appear, and again, for the record, for plaintiff Matthew Pallets, I'd ask for a default judgment be taken. Amount of rent retained is $4,731.53. Court cost of $167 for a total of $4,898.53.
Defendant having failed to appear as of 10:49 a.m. default judgment shall enter in favor of plaintiff and against defendant and the amounts placed on the record by plaintiff's attorney. Anything else in this matter?
No, Your Honor. Thank you.
Thank you. 210712 G&I versus Amber Davis. This matter having been scheduled for 9 a.m. It now being 10:50 by the court's clock. There being no one in the court's virtual waiting room by that name. Mr. Pallets.
Your Honor, in light of the fact defendant having failed to appear, ask for a default judgment be entered. The amount of rent retained is $3,397.44. Court cost of $167 for a total of $3,564.44. For the record, the tenant has disclosed the CDC declaration. I would ask that a default judgment be taken, writ date to reflect the 3/31 deadline.
I'll indicate for the record that there is no one in the court's virtual waiting room by the last name of Davis. There previously been a verification regarding CDC eviction moratorium declaration that indicated that the tenant had not yet filed. As attorney has indicated that that declaration form has now been filed. Inasmuch as the defendant has failed to appear this morning, default judgment shall enter with the terms placed on the record this morning by plaintiff's attorney. Anything else in this matter, Mr. Pallets?
No, Your Honor.
Ready to proceed, Mr. Robinson?
I was not able to reach Miss Seaborn. I just sent her a message asking for a phone number, but she did not even make it to the breakout room.
Would you call Jamie back here, please?
Excuse me? I'm
I'm
sorry.
sorry. Robinson and Seaborn never made it into a breakout room.
I made it in, but she did not.
And I sent her a chat and I didn't get a reply.
And I need a file back. I had her file, now I don't have it. I gave it to Jamie by mistake. Thanks. Thank you, Marianne. I had it and I put it on the side and then I can't find it. No, he saw a stack of pink files and so he took them. We're trying with Miss Seaborn. Her video's not connecting. It doesn't like her audio's connecting. We might have to remove her and have her try to call back in. Did she move into the breakout room or did she leave?
I bumped her out.
Thank you. As soon as she comes back, would you put her back with Mr. Robinson, please?
Yes, I will.
Thank you. 210710 GNI versus Lakeisha Humber. Thank you, ma'am. This matter was scheduled for 9 o'clock. It's now 10:53 by the court's clock. There is no one in the court's virtual waiting room with that last name. Plaintiff's attorney is present. Mr. Pallets.
Your Honor, in light of the fact defendant having failed to appear, as for default judgment, possession will be taken. Amount of rent to retain is $4,654.73. Court costs of $167 for a total of $4,821.73.
Inasmuch as the defendant has failed to appear this morning, default judgment shall enter containing the terms placed on the record by plaintiff's attorney this morning. Anything else in this matter, Mr. Pallets?
No, Your Honor. Thank you.
Thank you, sir. Oh, I see what happened. It's not good. Marianne, I'm telling you. 210716 GNI versus Marvin Burns. This matter was scheduled at 9 a.m. It is now 10:54 by the court's clock. There is no one in the court's virtual waiting room with the name of Burns. Defendant having failed to appear, plaintiff's attorney being present, default judgment shall enter. Mr. Pallets.
Your Honor, in light of the fact defendant having failed to appear, as for default judgment be entered at this time. Amount of rent retained is $2,978.32. Court cost of $167 for a total of $3,145.32.
Inasmuch as the defendant has failed to appear, default judgment shall enter the amount indicated on the record by plaintiff's attorney. Anything else in this matter, Mr. Pallets?
No, Your Honor. Thank you.
Thank you. This is 210722 GNI versus Ruby Peoples and Myron Peoples. This matter was scheduled at 9 a.m. It is now 10:55 by the court's clock. There is no one in the court's virtual waiting room by the last name. Plaintiff's attorney is present. Mr. Pallets.
Your Honor, in light of the fact defendants having failed to appear, as for default judgment be taken. Amount of rent retained is $4,055.79. Court cost of $189 for a total of $4,244.79. And as for default judgment be entered as prayed for.
Inasmuch as the defendants have failed to appear this morning, default judgment shall enter containing the terms placed on the record by plaintiff's attorney this morning. Anything else in this matter?
No, Your Honor, thank you.
Other than Seaborn, Mr. Palace, I believe that concludes this court's docket with your firm.
Your Honor, may I ask a question on a couple of matters? I might have missed them in the breakout room. No, actually, I think these have been dismissed. That's why they weren't called. So let me see this, the last matter.
Yeah, Emily pulled the dismissals last night, so I didn't see them.
No, there was confusion on this. What about 21-0724 Hollowell and Chalmers? Did we talk to them?
Carried that one.
You did already?
We did, yeah.
Very good. Okay. I think that was the only one I had a question on then.
Your Honor, what do we want to do about Miss Seaborn?
What do we want to do? What happened? Has she tried to call back? I don't see her trying to connect, but I know she was trying all morning. Do you have a phone number? Oh, we have a phone number for her. Oh, 1 second. Mr. Robinson, if you can try to get a hold of her, I just sent you the phone number because I've seen her all morning long. I am not inclined to enter a default.
I completely understand, Your Honor. I see the phone number and I'll give her a call right now.
Mr. Pallets, could you go back to 695? This was Country Metals versus Church and Carr.
$695. Yes, Your Honor.
What was the amount of rent in that file?
The amount of rent to retain was $4,669.27.
Thank you.
Yes. Okay.
I got the rest of it. Thank you so much, sir.
Very well. All right, if you don't mind, I'll just hang out and see if Garrett's able to connect. Otherwise, we would ask for a week adjournment to match the other case if that's possible.
I appreciate it. Thank you much.
Certainly.
Oh, shoot.
Would you like me to bring in the attorneys?
I was just doing it because I saw them hanging out there and I know we said approximately 11 o'clock. This is 210730 Airport Park versus Sunrise Express.
Good morning, Your Honor.
I'm listening, sir.
Yes, hi, someone got CP number 68565 on behalf of the defendant.
Ma'am?
Yes,
Are you
my name is Jennifer Babala.
Are you
sorry?
standing in for Mr. Bolton?
No, he said he was in the waiting room as well. So I'm just, I'm on behalf of the landlord if there was any questions.
You're the party. Okay. I don't see that Mr. Bolton's back. He told us that he had bankruptcy court. As soon as he pops back on, I'll call the case, okay?
Sounds good.
Sit tight. Mr. Robinson, were you able to get a hold of Ms. Seaborn?
No, Your Honor. I called her twice, but I wasn't able to get through.
Thank you. Mr. Palace has indicated, I'm sorry, 210697 LT Green Meadows Apartments versus Jaslyn Seaborn. Mr. Robinson, Mr. Palace has indicated that he would not oppose a 1 week adjournment due to the fact that Miss Seaborn has been trying to get on all morning. I've seen her off and on all morning long.
I am agreeable to that.
Thank you. I'll put it over to 3/17/2021. I'm gonna schedule it for that same 9 a.m. as the Negus matter, but I'll call Seaborn first if she's on.
Thank you, Your
Very
Honor.
good.
Thank you. We're all set. If she comes back on, I'll let her know that that's what we're inclined to do.
Thank you very much.
Thank
Thank
you.
you, Your Honor.
Have a good day.
Oh, Your Honor, just for clarification, what email address do you want us to send all our paperwork to?
You don't really want me to answer that. I think Mary Ann will chat you. Or
Very good.
can you do that for me, please? I'm sorry, she's calling somebody. I know I made a mistake. Yes, thank you. No, I caught it and I was coming to get you right now. What happened on this case is that Matthew Pallets distracted me by all of his computer monitors in the background, and I knew what happened and I just couldn't fix it in time.
Were you talking about my computer monitors? Is that what you said?
Yeah.
Well, actually, this is ADD theater. I'll show you. I've actually got, look, 4. My wife says this is ADD theater right here.
You? No,
I know.
that would never happen. Well, the funny part is I don't have that many monitors, but what I have is different devices trying to do 9 things at the same time. So I'm giving that one back. Miss Seaborn could not connect. She might call you all, but I'm putting that on. Mr. Robinson was here. Those are good to go, but not connect. I'm putting 2 over to next week, which is not my time to do it, but I'm going to do it because it's St. Patrick's Day. And we might as well have landlord tenant on St. Patrick's Day. We're going to adjourn to 3/17/2021 at 9 a.m. There's 2 of them at 9 a.m. If you all would be so kind as to send out notices. The Seaborn file, she was trying to connect off and on all morning and she could not. So I'm putting them over. These 2 are the 2 that are back next week. Thank you. I have one more hearing. And I only have 1 file left, which means something good.
Your Honor, I received the email via the text direct message. Thank you, Your Honor.
Thank you. I think that's my secretary's email. And we send them over. We'll put that stuff in the file. Thank you so much. You all have a wonderful day. Mr. Robinson, Mr. Powell.
Thank you, Your Honor.
Thank you very much.
Ma'am, as soon as the attorneys show up, we'll call the case, okay?
Sounds good.
Thank you.
Yep. Hi there.
Now he's gotta wait for the other people to get back
Yep.
on.
Yeah.
Good morning, Ian.
Good morning.
How are you?
Okay, how are you doing?
Good, excellent. So, like this, I said before, the only issue that we have is the extra legal.
Well, hold on, before you keep going, I don't know if the judge can hear us.
Well, not
Oh.
yet, no, but I can put you in a breakout room. She's
No,
not.
don't worry about it, because I know his position. I thought that, don't worry about it, no.
Okay.
I spilled coffee on myself this morning. Is it obvious?
No, I don't see it.
All right, good.
It's very obvious. You look a mess. Please go change. This is 210730 LT Airport Parking versus Sunrise Express. Your appearances, please.
Good morning, Your Honor. Ian Bolton on behalf of the plaintiff landlord, Airport Park.
Good morning, Your Honor. Haitham Qudsi on behalf of defendant Sunrise Express.
And Your Honor, I have with me today, Ms. Jennifer, and I'm probably butchered the last name, Babila?
Babila.
Babila.
Babila. Everybody says Babila, so I'm used to it.
Who is a representative from the management company for my client and is prepared to testify about the ledger and the amounts owed.
Are the parties are ready to proceed this morning?
Your Honor, my client is not available today. And the only reason, because he have today a lot of work, he could not make it. I am asking for adjournment just a week. The only issue in this case, Your Honor, is that the plaintiff is suing my client for legal fees from a very previous eviction. They tried to send him a notice many times, and now they are billing him for all these times, despite the fact that they file a eviction, they settle, he continued paying the rent. Now they are suing him for all the previous legal fees. So this is one issue that we have. And I needed, I never received from Mr. Ian. He was very nice. He sent me the document, but he never sent me the legal fees. I asked for the new legal fee, and he never did. So
my question to you is, when did you realize that your client was not going to be available today?
Actually, from yesterday, he told me that.
So you knew yesterday that you weren't ready to proceed this morning. Did you call Mr. Bolton's office and advise him of that?
I did not.
Okay.
I apologize for that. I did not know that this is it's gonna change anything. Because even if I told him that, he would say it's not my problem. But it's
no. But what would have happened is I would have called the case the first time before you went to Macomb and he did the 341. I understand, but I'm just saying I would have given you a new date an hour ago versus this. It doesn't matter to me because I'm here. It's just as a matter of courtesy, disposing of the matter as early as possible. And the first time I called it, Mr. Bolton, your response to the request for adjournment.
Your Honor, I'm not sure what information the tenant could have that's all that relevant in this case. But that being said, I would understand the adjournment given that one of the parties isn't present. I'd also note for the record, because one of the issues in this case is that legal fees. There's legal fees incurred for having to show up today, and there'll be legal fees incurred for having to show up next week or whenever we have this hearing again. And in addition, the interest and the rent will continue to accrue as well.
I understand.
So it sounds as if you're not objecting to the adjournment based on the party's unavailability. Is your client going to be available next Wednesday, St. Patrick's Day, March 17th at 10 a.m.?
Somebody from my client, do you want to confirm?
Mr. Bolton, not you, I'm sorry.
Oh, I'm sorry. I thought you were asking me.
Oh, I will ask you, are you available on that day at that time?
Gotcha.
You are?
I'm available. Let me confirm. At what time, Your Honor?
10?
I will be available.
And on behalf of the defendant?
Yes, Your Honor.
You're available and your client will be available?
Yes, he have to. Yes, 100%.
Famous last words. I will see you next Wednesday at 10 a.m. The clerks will provide notice. We'll use my same Zoom number. There's only 2 other things scheduled for that morning and they're at 9. So at 10 o'clock, we're going. If something changes or you all reach a settlement agreement, the court will await receipt of documents, okay?
Thank you, Your Honor.
Thank you. We're all set. Have a good day.
Thank you.
You too.
Bye-bye.
Bye-bye.